Hello friends, with the initiative of Company Law Institute of India Private Limited, in the series of income tax cases, today we will discuss a very important case of Gujarat High Court which has been decided in the writ petition. The name of the case is RAKESHKUMAR BABULAL AGARWAL versus Commissioner of Income Tax, and this case has been reported in 448 ITR at page number 133. The matter has been decided on 7th March 2022. The facts of the case are very interesting. In this case, the assessee is a trader in jewellery. The assessee purchased some jewellery through courier, and when the courier was being delivered to the assessee, this courier was intercepted by the income tax department, and the statement of the courier boys were recorded under section 132 subsection 4, in which the courier boys admitted the identity of the seller and the purchaser of the jewellery. The assessee produced the purchase bill. The assessee produced the bank statement in which the payment to the seller was reflecting. The assessment of the seller was completed under section 153A and substantive addition was made. The seller was not able to make the payment of the tax, and the protective assessment was done in the hands of the assessee under section 153C. The allegation of the learned assessing officer was that since the seller has denied the transaction with the purchaser, so the genuineness of the transaction was not proved. It was the allegation of the learned assessing officer. But the learned assessing officer ignored that the purchase bill has been produced, the payment through banking channels have been proved beyond doubt. The assessee produced the stock register in which the stock was entered by the assessee, and the protective assessment was made. When the assessee went to the CIT appeal, the CIT appeal deleted the addition. The CIT appeal said that even if it is assumed that the seller version is correct, that this transaction is not being done with the purchaser, but still the assessee has recorded this transaction into the books of accounts. And when the transaction is recorded into the books of accounts through the purchase bill and the payment through banking channels, then the addition under section 69A cannot be made, because 69A addition is possible only when it is not recorded into the books of accounts. So in this particular case, the CIT appeal deleted the protective assessment made in the hands of the assessee under section 153C. So the assessee moved an application for the release of the jewellery, but the department denied the release of the jewellery on the point that there is a substantive addition in the hands of the seller and the seller is not making the payment of the tax, so the jewellery cannot be released. So the assessee moved to the writ court, and the court said that since the CIT appeal has done the judgment into the favor of the assessee and the department has not gone into appeal against the order of the CIT appeal, so there is no tax liability of the assessee and the jewellery should be released to the assessee. And accordingly, the High Court ordered the Commissioner of Income Tax to release the jewellery to the assessee as soon as possible. The point of the court was that the assessee has won its case in the CIT appeal and the department has not preferred an appeal, and also reiterated the order of the CIT appeal that once the assessee has proved the transaction beyond doubt through the purchase bill and through the banking channels, then only on the statement of the seller denying the transaction with the purchaser, the handing over of the jewellery to the assessee cannot be denied. Since there was no demand of the assessee, since the assessee has got its case through the CIT appeal and the department is not into the appeals, so it cannot be said that that the amount of the jewelry can be adjusted against the demand of the seller. So in this particular case, the assessee got its jewelry back through the writ petition. At the end of this video, once again I am repeating the name of the case. The name of the case is RAKESHKUMAR BABULAL AGARWAL versus Principal Commissioner of Income Tax. And this case has been reported in 448 ITR at page number 133. Thank you, friends.